Just put it on.
Okay.
Thanks.
Stand, please. Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 23-3080, United States of America versus Eghbal Saraphinia, also known as Eddie Saraphinia, appellant. Ms. Fischel for the appellant, Ms. Ralston for the appellee.
Ms. Fischel. Good morning.
Good morning. Thank you, Your Honor. May it please the court. Section 1519 requires intent to obstruct an investigation or the proper administration of a matter. There are two potential investigations or matters in this case. One was never charged by the grand jury, and the other falls outside the statute's reach. I would like to focus this morning on those two defects and why they require Mr. Saffarinia be granted acquittal, or at the very least, a new trial on his 1519 counts. Starting with the never charged investigation. That is the investigation that SIGI and the FBI conducted into contract steering, which was not alleged in the indictment because it was never offered to the grand jury as a basis for the charges. It was never charged by the grand jury. But within days of trial, the government declared it an important basis for the counts, for the 1519 charges. That constructively amended the indictment because the indictment at page 543 of the joint appendix says that what the only investigation or matter at issue in this case that was charged was the obstruction of HUD and OGE's review of forms 278.
Counsel, Can you direct me to any language in the jury instructions that permitted the jury to convict your client based on this other investigation?
The jury instructions, it authorized the jury to make the factual determination about what fell within the jurisdiction of HUD or OGE. It described what the jurisdiction, it described the jurisdictional element and said any authorized function of an agency, and then it named HUD or OGE. The government's argument in closing specifically invited the jury to make that finding, which we contend should have been a legal finding, and we objected to authorizing the jury to make that determination. But the district court permitted the government to make the factual argument that somehow HUD and OGE's jurisdiction extended to the FBI and SIGI investigation, and the jury could have believed that argument. Nothing told them that they were not permitted to follow the government's argument when it made that argument. And that is exactly that, the fact that they were permitted to make that inference, to believe the jury's argument that the SIGI FBI investigation fell within the scope of HUD or OGE, is why this was a constructive amendment. And we know it was because the government conceded repeatedly pre-trial that the grand jury's charge was limited to review of the forms. Nothing in the jury instructions limited the jury to finding review of the forms was the subject of the obstruction here. For example, the government conceded at page 222 to 223 of the joint appendix, they said, to be clear, the indictment alleges, and then they identified the subject or matter of the investigation or matter as, quote, review of the forms 278 or, quote, receipt and review by HUD and OGE. At page 86 of the joint appendix, they also specified that the indictment was adequately alleged because it named agencies tasked with, quote, reviewing that form. At page 2117 of the joint appendix, they conceded that the grand jury had charged obstruction of HUD and OGE and no other agency. But they argued something different to the court and to the jury, and the jury could have convicted on that basis, and nothing in the jury instructions, Your Honor, prevented them from doing that. The district court accepted those concessions over and over as well. The district court agreed that the indictment was clear because it named, quote, agencies that reviewed those forms. The district court found, quote, review of his OGE forms was the adequately alleged matter or investigation. And the district court denied the grand jury discovery based on the government's representations. There was more. In a letter, in motion in limine papers, in pretrial hearings, throughout the pretrial process, up until days before trial, the government consistently and repeatedly said,
I'm having a little trouble with understanding your argument in the sense that HUD and, I mean, the FBI, it doesn't get to the FBI or any later stage of the investigation unless the other agencies review the documents first and then deem them worthy of referring them further. So, I mean, the jury, in order for your theory to be viable, we have to ignore the fact that there is a prefatory review that necessarily took place.
No, Your Honor. And the reason is because the prefatory review was entirely separate from the SIGI FBI investigation. You're correct that the government argues certainly there could have been something that arose out of these forms. Nothing arose out of these forms. And they concede that the SIGI FBI investigation germinated from outside allegations at page 13 of their brief. And that is critical because nothing in the indictment said anything about that exterior investigation. All the government would have needed to do in this case is charge the grand jury with the SIGI FBI investigation into contract steering as the basis for the obstruction counts. They knew about that investigation, but they didn't charge it, as they repeatedly conceded. They didn't charge it, and they didn't raise that with the district court when we challenged the sufficiency of the allegations, and they didn't in the lead up to trial, they argued background and context as the reason for entering this evidence into trial. It was only after the district court excluded the evidence as background and context because it would be unfairly prejudicial that the government said this was a basis for the charges. That was a classic constructive amendment. And here it results in acquittal because Section 1519 does not criminalize the sole surviving basis for the charges, which is the routine review. Marinello is directly on point there as to the definition of proper administration of a matter. And it is not an investigation, as the government practically concedes in their brief. And I see I've entered my rebuttal time, so just one final note. The government argued for the first time on appeal that we forfeited our jury instructions argument. I would just direct the court's attention to page 2532, that's 2532 of the joint appendix, where the district court found there was an objection and a request for a new trial on the jury instructions issue before it addressed our argument. I will reserve the remainder of my time if there are no further questions. Thank you.
Thank you. Ms. Ralston.
Good morning, Your Honors. May it please the court. I'd like to begin with the argument the government changed its theory midstream here. This is simply not true. The government alleged and continued to argue for and prove to the jury that this was one single investigation within the jurisdiction of HUD and OGE. I point the court to the indictment language at 543, which does not, contrary to my friend on the other side's argument, say the word review at all. It repeats the statutory language, including in contemplation and relation to an investigation and the proper administration of a matter within the jurisdiction of a federal agency. The identified agencies are HUD and OGE. The district court's jury instructions, as the court itself found, were virtually identical.
Yeah, but the question is whether or not you presented significant evidence regarding the CGIE and FBI investigation, which I think you did.
So I think that would go to whether there's a variance, not an
Yes.
amendment.
All right, I understand the difference, I think, between
Yes.
variance and amendment, but you still have a problem. It's a variance, and it sure looks like at least a variance. There's extensive evidence on the CIGE, and they tried to get the district court to cut them a break by raising an objection, and the district court allowed it to go ahead and proceed during the trial. There's extensive evidence. It's not in the indictment, and I agree there's consistency between the indictment and jury instructions, but it's inconsistent with the evidence, extensive evidence that you put on a CIGE and FBI investigation. The CIGE and FBI investigation are not what the indictment is about, and yet there's extensive evidence on it. My understanding is that's a variance.
I disagree, Your Honor, for three reasons. The first is that the indictment alleges, it's a speaking indictment, and it alleges in the first 11 pages, which are reincorporated into the counts 5 through 7 charge, that the conflict of interest, the investigation here, to the extent we're talking about investigation, is into the conflict of interest. Okay. Second, whether that investigation into the conflict of interest was within the jurisdiction of HUD and OGE is a question essentially of agency. Whether the FBI agent was acting as the agent of HUD or OGE. This is, as the district court found twice at pages 28 and again at 2523.
On the thrust of what you're arguing now, are you suggesting the indictment included the CIGE and FBI investigation? Because you conceded post-trial that that was not the case. You conceded it. I'm looking at your quoted words here. They were not charged or instructed that the investigation on the matter obstructed was a CIGE or FBI investigation. That's your concession.
I agree, Your Honor, but that's because there is no separate investigation. There is a single investigation into the conflict of
There are
interest.
two very distinct things going on here. One, that maybe they're all chargeable, but the only thing that was charged did not include the CIGE FBI investigation. Absolutely did not. In fact, you said that. And yet your testimony went extensively to that. That's prejudicial.
I disagree for additional reasons. So first, I want to go back to the extensive evidence. CIGE or the FBI is mentioned only on 12 of the 1,000 pages. Most of that is about the fact that a referral was made. The FBI agent gives one paragraph giving his foundation for how he then is in the position to testify about the records that he goes on about. It's not extensive records. Moreover, I think this factual question, right? The district court before trial at page 28 calls it a question of fact for the jury. The jury instructions in no way permitted the jury to convict on the basis of.
Doesn't matter if you're looking at a variance.
I disagree to some extent
You can't
because
disagree because you know that's not the law. And when you're talking about a variance as opposed to an amendment, if you have extensive evidence that's inconsistent with the indictment and the instruction, that's a variance.
so I want to go back
Because the
to
prejudice is they weren't able to prepare and put in testimony to deal with something they didn't expect to see and that the district court was not allowing them to get into.
So a variance deals with the concept of notice. They had completely fair notice that all investigations into the conflict of interest were part of the charge. You look at the speaking indictment, the reverse proffers.
No, wait, let me come, you're mixing me up. Now are you saying that the CIGE and FBI investigation were included? Because you conceded they were not.
As we argued throughout the case, and I'd point you to the point at pages 807, at 820 and 860 at the pretrial conference, where the prosecutor repeatedly says it's not a different investigation. CIGE and FBI stand in the shoes of HUD. The district court
Counselor,
finds.
Post-trial, someone conceded. Jury was not charged or instructed that the investigation of matter obstructed was a CIGE or FBI investigation.
Yes, we did not charge, we did not prove, we did not ask the jury to convict on any basis that the investigation was within the jurisdiction of CIGE and FBI. The investigation is within the jurisdiction of the charged agencies, as we made clear throughout. But I want to go back to this notice point. I think notice at the end of the day comes down to the question of what would have been different if they say we changed, if that's true, what would have been different? And nothing. And I think that's clear because it's all one case. If you look at count one urges concealment based on an intent to deceive. That is a scheme or trick, right? All of that has to go to this idea that there's a conflict of interest, a potential conflict that's covered up by the lie on the form. That's the case, right? That's the case throughout all of the charges. Those are the facts. He had noticed that that was the charge, and that charge that he defended against in count one, in all the counts, he had a single defense. His defense was it was an honest mistake, okay? There's no honest mistake. The jury rejects that when they convict him on all 7 counts. There's no other defense. There's nothing else he could have said. And this was within the jurisdiction of HUD and OGE. That's the only thing the government asked the jury to convict about.
And what I would have done if I were counsel on their side is their subpoena and discovery would have been entirely different if they knew that the CIGE and FBI investigation was in play. And I certainly would have had a very different discovery if I had known, oh, that's in play. Oh, we're going to be here a long time on discovery because we're going to go into all of that. Had I known that. And you conceded post-trial that wasn't, and yet you put in extensive evidence that it was.
So it's not extensive, 12 pages, okay? It's not even 12 full pages. It's parts of 12 pages, and I refer you to the citations in our brief about that. It is, however, there was no more discovery. The government gave all the discovery. This includes 3,600 pages of files from ODNI, which is the agency to which CIGE enlisted to stand in HUD's shoes because of the recusal. There was nothing else to give them. Okay, we highlighted the hot documents for them. The district court found that that was sufficient at 488. We were consistent. There were reverse proffers. They had complete notice about the conflict of interest investigation that was this. And I would point out that until Mr. Saffarinia was terminated from HUD in 2017, HUD still had a strong interest in figuring out whether there was a conflict of interest and whether he lied on those forms, because those helped form the basis of his termination. So I think there's a good reason, not only that this was the argument in the jury instruction, but that there was reason, factual reason, to understand that this was within HUD's jurisdiction. Also, OGE has jurisdiction to investigate these forms. And I think that's clear both in the statute, it's clear throughout the Bill of Particulars. I think at 222, we talk about OGE's power to investigate. And also I want to talk about the contemplation on this idea of 1519. We have the contemplation or relation to language. It doesn't have to be the actual investigation that he's obstructing. It can be any, investigation within the jurisdiction of the charged agency that he would anticipate. And we made it clear that we were talking about contemplated investigations throughout. I think 220 in the motion to dismiss response, 85 to 86 in the Bill of Particulars response, highlight that clearly. And the last thing I want to just point out both here about the variance and about 1519 is that a variance, according to Jordan, has to go to an essential element of the offense. The essential element here are two things. First, it's the intent to obstruct, and second, it's the false document. There's no dispute at all about the documents or that they were false, and the intent to obstruct is the same. It doesn't matter who the agency is. I'm not saying that we changed the agency, but the intent is the same. The intent is to cover up the conflict of interest, and that was the argument throughout trial about all 7 counts. Okay, the intent that's the scheme to conceal, is the intent to cover up this conflict of interest. And moreover, I think some of the SIGI evidence, at least, would have been admissible regardless, and that goes to his notice. There's discussion that he knows about this investigation by the time he files that last form in 2016. And so at 1116 and 1606, the references to SIGI are about that awareness. Okay, so that's not, I think, in any way saying that he, in varying from the indictment, right? The other things go to materiality. They would have been admissible anyway. They're saying that I would have made this referral. That's what Antonia says at 1596. They're talking about follow-up information at 1069. That's internal to HUD OIG investigation, right? Kirkland is going out and gathering evidence. He's interviewing witnesses. He's gathering documents, and that's inside HUD. And then he says he provides that information to SIGI. But the fact that he provided the information isn't the necessary part, right? The necessary thing there is that he's gathering the information. And as we point out in our brief at page 27, that is an investigation well within the jurisdiction of HUD. And I think under the jury instructions, that if the jury relied on the investigation prong at all, as opposed to the administration prong, then I think that's the better idea of what they were relying on, because his
All right, Ms.
investigation.
Ralston, you're over your time. If there are no questions, Judge Wilkins.
One last question. What's your response to your friend on the other side's argument that based on the jury instructions, the defendant could have been convicted not because of an investigation by, I guess, HUD and OIG, but because of an investigation by the FBI or CIG?
I think it's not possible in any way. The jury instructions mention the statutory, the indictment language. They copy that verbatim, which says HUD and OGE. The unanimity instruction, additionally, is explicit that the jury has to find it's a matter within the jurisdiction of HUD, unanimously agree that it's within the jurisdiction of OGE, or both. There's no way that the jury could have followed both of those instructions, or really either of them, and convicted on the basis of something that's within the jurisdiction of another agency. I'm not disputing that there was someone referred through SIGI and an FBI agent who did some of the investigating that I think could have been contemplated by the defendant, but those people were acting as agents of HUD because HUD OIG was recused because of the defendant's position. So the jury instructions, I don't think in any way allowed this conviction. and he received completely fair notice. It doesn't go to an essential element. And just one last thing I'd like to say is that throughout, the standard of review is an issue for the court. Okay? That Rule 52, Rule 30 are addressed to what may be considered, which is by the court. It's not something I think that the party can waive it. In any event, didn't waive it below. If there are no further questions.
Thank you.
Thank you.
May it please the court, I have 3 points I want to quickly touch on in rebuttal. The first is that there is no way to read this indictment as providing notice to Mr. Saffarinia that he could be put on trial for obstructing a conflict of interest investigation or contract steering investigation. That means that there are 2 ways to resolve this case. Either the government was right when it opposed the bill of particulars, motion to dismiss, when it opposed our motion for grand jury minutes, that the indictment was limited to routine review of the forms, or the indictment is fatally vague and fails to provide constitutionally adequate notice of the charges to Mr. Saffarinia. If the former, acquittal is required. If the latter, the district court denial of our motion to dismiss should be reversed. On the jury instructions cure point, the jury instructions here were not consistent with what the grand jury charged, which is the essential question here. The government concedes at page 35 to 36 of their brief that the jury could have convicted based on evidence of the SIGI FBI investigation. That is not what the grand jury charged, as the government also conceded below. And that question should not, of whose jurisdiction the SIGI FBI investigation fell within, that was a legal question that never should have been sent to the jury. What happened in the jury instructions is the court permitted the jury to decide whether or not the SIGI FBI investigation fell within the jurisdiction of HUD or OGE. That should never have happened, but it did. And I would directly—
I don't understand your argument. You're saying that it's a legal question that shouldn't have been sent to the jury. Well, did the jury answer it incorrectly? I mean, legally, were they acting as agents for OGE and HUD? And if so, then what's the error?
Legally, they were not acting as agents, Your Honor. This was a completely separate investigation by completely separate agencies that was referred out of a bid protest, which related to contract steering and not the forms. And it would make no sense for a referral out of an agency that is specifically to avoid a conflict of interest to result in something still being within the original agency's jurisdiction. I would just add, Your Honors, that there was certainly prejudice here. There was no notice, and we would have proceeded on a different strategy, reviewed discovery differently, if we had known that the government would assert this as a basis for their charges. If there are no further questions, my time is up.
Thank you.
Thank you, Your Honors.
Case number 23-1239, Trenton Palmer, petitioner versus Federal Aviation Administration, Administrator, and National Transportation Safety Board. Mr. Schulte for the petitioner, Ms. Park for the respondents.
Let's wait till the courtroom is clear. All right, Mr. Schulte, good morning.
Good morning, Your Honor. Member of the bench, good morning. My name is Robert Schulte. I am counsel for the petitioner in this case, Trenton J. Palmer. Appreciate the opportunity to be here today, and I look forward to entertaining any questions the court may have. With that said, we're here today seeking a reversal of the decision of the NTSB board in this matter and a vacation of the order of suspension had against the petitioner. We do this for a couple of reasons, not the least of which is that during the course of this matter, the petitioner received process, but he did not receive due process. And what I mean by that is that during the course of this proceeding, the NTSB and the administrative law judge seems to acknowledge that The Federal Rules of Evidence and the Federal Rules of Civil Procedure now apply in air safety proceedings. They acknowledge it, but they don't do it. They seem to give lip service to it, but in fact are not faithfully applying the rules of civil procedure or the Federal Rules of Evidence. And indeed, as late as 2021, the NTSB referred to the congressional mandate set forth in the Pilot's Bill of Rights. They follow these rules as quote unquote non-binding guidance. Pilot Bill of Rights is quite clear. The NTSB and the FAA and air safety proceedings shall follow the rules set forth in the federal rules, the FRE and the FRCP. It is true that it is conditioned as where practicable, but the NTSB has never identified any case where it stated in writing that the following of these rules was quote unquote impracticable. And that includes, by the way, Federal Rule of Civil Procedure 8A, the pleading standards set forth in that rule as articulated in the Eghbal and Tromley cases, which I expect this court is well familiar with. In this case, at issue was 14 CFR 91-119. It's a fairly straightforward and simple regulation that states that no pilot may operate an aircraft within 500 feet of persons or structures on the ground, except as necessary for takeoff and landing. So what does that mean? Unfortunately, there's no standards to determine what is necessary for takeoff and landing, and several courts have criticized the lack of standards on that point. But in this case, Mr. Palmer was conducting something called an off-airport landing. It is a landing, as its name suggests, not on an airport as you and I would typically understand it. No federal aviation regulation precludes off-airport landings. And so when the off-airport landing is done, it is typically done pursuant to FAA guidance published in its own document called the Off-Airport Operations Guide. That's what the petitioner was doing on the day in question. There's no meaningful dispute on that point. The FAA's expert, a gentleman named Roy Speig, did state in no uncertain terms that in order to conduct an off-airport operation prudently and safely, you should do it in accordance with the FAA's own guidance. Indeed, he conceded that, in fact, it was necessary to conduct an inspection pass during the course of an off-airport landing. With that concession, as far as the petitioner is concerned, the case was over. Because once the concession is made that the operation is necessary for landing, not when landing, we'll come back to that indeed the distance and altitude restrictions fall away. That's where that case should have stopped. But it didn't stop there. This case took 5 days of testimony involving all manner of facts that were never alleged in the administrator's complaint. The administrator's complaint, to be charitable, is anemic. It simply takes the language of the statute and turns them into affirmative statements. This is exactly the caution of Eghbal and Tromley. You can't do that. We are not suggesting for a moment that the administrator needed to plead each and every factual allegation he decided to prove in his case in chief. But he has to set forth the facts and circumstances that identify why this operation was a violation of 119. Because every takeoff landing operation, every missed approach, every practice approach where no landing is intended, oftentimes will take an aircraft within 500 feet of persons or structures on the ground. Under the FAA's rationale of this case, every one of those operations is a violation unless the airman stands up and defends himself. That cannot and is not the law. And indeed, the NTSB in its own decisions has clearly stated that operations that do not involve landing but necessary for takeoff and landing, such as missed approaches, such as practice approaches, such as other missed opportunities to land, do in fact fall within the prefatory clause of except as necessary when takeoff and landing. But again, the FAA's complaint is devoid of any facts that would inform that. For example, one of the other allegations under 119 is that in the event of a unit power failure, the aircraft would pose an undue hazard to persons or property on the ground. The FAA made that allegation as an affirmative statement, but it begs the question, why? What about this particular operation rendered it unduly hazardous to persons or property on the ground? There's no facts in the complaint that speak to that. Is it the proximity of the aircraft to persons and property? Well, that can't be it, because their expert, Mr. Speak, testified that that happens all the time. So what else was it about this operation that made it unduly hazardous to persons or property on the ground? There are no facts in the complaint that inform that allegation. It's just a recitation of the elements of the cause of action, again, without any underlying factual allegata. And that is what's prohibited by Eghbal and Trombley and what is required by Rule 8A. Likewise, my client never disputed he came within 500 feet of persons or property on the ground. And yet we spent days talking about that. It wasn't necessary. This is a simple regulatory violation. And likewise, the distance measurements in the complaint, where they say he operated within 150 feet of this structure, 200 feet of that person or property, that's all fine and well. But again, specialists conceded that that was necessary to conduct an off-airport landing. So that couldn't be the violation. So where the FAA went next was to suggest, again, unpled in the complaint, that somehow the landing site was inappropriate. And we talked about that for a while during the course of the proceeding. And then when the FAA took the position that because the petitioner was not landing at that precise moment and that he did not intend to land, because again, it's an inspection pass, it's not an inspection landing, she said, well, that's no longer an issue in the case. And I agreed. And this gets into the next issue of what the administrative law judge did in this case. And with all respect, when the FAA abandoned the issue, and I agreed and ceased my questioning on that point, he took up the issue. And it's the administrative law judge that reintroduced an issue to the case that both parties agreed was no longer relevant. I would submit to your honors that was inappropriate and frankly highly prejudicial to my client. In fact, it informed no small part of his decision. As far as the inspector goes, Mr. Speed, he spent the bulk of that hearing giving legal opinions over the objection of the petitioner. That was inappropriate. It never should have been heard, and certainly inconsistent with the federal rules of evidence. Mr. Speed, with all respect to him, was hopelessly incompetent to testify about this particular case because he knew nothing of the petitioner and he knew nothing of the aircraft. And yet, during the course of his testimony, he said, yes, the appropriateness of the landing site is a function of those things. And although he intimated that the landing site was inappropriate, he had no factual basis to make or offer that opinion at this particular proceeding. And I'd also like to point out one other thing too. On the issue of expert bias, while I accept that it is the administrative law judge's discretion to hear testimony, there are some points where an expert goes too far. And we cited the case law in our brief. But when an expert interest is so closely aligned with the person for whom he's testifying, it's inappropriate to hear that testimony. I am not suggesting for a moment that the FAA cannot offer experts, subject matter experts, in a hearing such as this. Certainly they can if the expert meets the Daubert standards and the standards set forth in Federal Rule of Evidence 403 for the testimony of experts. But when an expert like Mr. Speed boldly celebrates the fact that he gets time off cash awards and accolades for doing a good job for the FAA, including testifying in air safety proceedings, I think that's a bridge too far. His bias in this case was institutional, and he was proud of it. And I'm not trying to make a pejorative statement against the expert. I'm merely suggesting that in this particular case, he essentially conceded that he was there to testify against the airman. He was not there to bring a body of experience to bear upon an objective set of facts. He was there to punish. And I think that was pretty clear from his testimony. He was merely putting the imprimatur of expert upon something the FAA had already decided. With that said, my time is up. I will yield at this point unless your honors have any questions.
Thank you.
Thank you, Your Honor.
Ms. Park? Good morning.
Good morning. May it please the court, Joy Park for the administrator and the Federal Aviation Administration. My friend, Mr. Schulte, highlighted almost every single argument in petitioner's brief. I'm not going to take the time to respond to every single one of those arguments, but I will respond to two of them. First, regarding the necessity here. In this case, it's important to note that from the outset, Mr. Palmer admitted that his low flight was below 100 feet above ground level and within 500 feet of structures. Thus, unless his flight was necessary for takeoff or landing, he violated the FAA's regulations. In this case, the administrative law judge found several different reasons why Mr. Palmer's low flight was not necessary for landing. One being that there was no emergency. Two, because Mr. Palmer had safer and more reasonable options for conducting this low flight. Three, because Mr. Palmer had the option to refrain from conducting this low flight. And fourth, because the runway was not suitable. In this appeal, Mr. Palmer only challenges that last finding regarding the suitability of the landing site. But as I just pointed out, there are many reasons that the administrative law judge gave for why Mr. Palmer's low flight was not necessary, and Mr. Palmer did not challenge those except for the suitability of the landing site. Second, turning into the federal rules, Amici in this argument inappropriately asked this court to issue a judicially reviewable finding requiring the NTSB to apply the federal rules. First of all, this argument was not presented by any of the parties, and as this court has held in Narragansett Indian Tribe versus National Indian Gaming Commission, the court generally does not consider arguments not presented by the parties. Moreover, this was an argument that was never presented to the NTSB, and now Amici are trying to bring a broad attack on the NTSB's adjudication practices without even giving the NTSB the ability to respond. With regard to the Pilot's Bill of Rights, Amici admit in their brief at page 5 that the actual language of the statute says that the NTSB should use the federal rules, quote, to the extent practicable. And finally, in this case, the NTSB appropriately applied the federal rules. And so there is really nothing for this court to do with regard to Amici's argument regarding the federal rules. Unless the court has any questions, I would like to conclude by briefly just highlighting what this case is all about. In November 2019, in Reno, Nevada, Mr. Palmer operated a low flight at an altitude below 100 feet above ground level and within 500 feet of a mother and her child, a home, a stable, a shed, and a 500-gallon propane tank. This low flight was not necessary, and therefore it violated the FAA's regulations. Thus, the FAA respectfully requests this court to affirm the NTSB's decision and deny the petition for review.
I do have a question, Ms. Park, about the statute. And do you have 44709 in front of you?
Yes, Your Honor.
If you look at B2, it says the board may modify a suspension or revocation of a certificate to imposition of a civil penalty. Now, there's one way to read that it's changed from the suggested 60 days to 120 days is not allowed under this, that they could have only imposed a civil penalty instead of the suspension. How do you read that language in 2? In other words, the board is limited to modifying a suspension here, the 120 days, to a civil penalty.
Well, Your Honor, respectfully, I don't believe that D2 applies in this scenario.
Okay, that's what I'm interested in knowing, because it speaks to when the appeal goes from the administrator to the board, and it leaves out the ALJ. And the board, in its closing remarks, or its actual rulings, says the respondent's appeal is denied, the administrator's appeal is granted, and the law judge's reduction is reversed. So I think I agree with you that that language does not apply to this case because of the ALJ's participation in it.
Right. I don't think the ALJ's participation really impacts what occurred here. But I mean, what the ALJ did was he did, there was a little bit of confusion in the record about why the administrative law judge reduced the penalty to 60 days. He had categorized this as a careless violation. But that specific finding, actually, Mr. Palmer doesn't challenge in the appeal. The only thing that he challenged was any deference that the NTSB may have given with regard to the penalty in light of this court's decision in FAM versus NTSB.
Let me ask you this then. If we hadn't had the ALJ, if it had gone directly from the administrator to the board, and the administrator had given 60 or 120, under D, do you think the board could have changed that sanction to anything other than a civil penalty?
Again, I think in the context of this case and the facts, the FAA would not issue a civil penalty. I'm sorry, I'm not sure if I'm understanding your question properly.
Well,
but
it's a hypothetical. I'm saying if we had no ALJ, if it went directly from the administrator to the board, it seems to me that if we had that, the board is locked in if it's going to modify a suspension to a civil penalty.
I don't think that that's the way that B2 functions. I think that B2 applies when we have a case in which there is a civil penalty, which there is like a dollar amount. But that's not the case here. Here, the penalty was a suspension of 120 days of Mr. Palmer's private pilot certificate. And again, under FAM, the NTSB appropriately found that the FAA's suspension of 120 days was justified in law and in fact.
Thank you. No more questions. Thank you.
Great, thank you.
Does Mr. Shulkin have any time left? All right. Does anyone have any questions? Judge Wilkins?
I have no questions.
All right, Judge Eghbal? All right, then.
Your Honor, thank you. I'll be brief.
No, that's it. Thank
Oh,
you.
okay.
You have your case.
As I said, I'll be brief. Thank you, Judge.
Case number 23-5122. Iowaska Church of Healing, Eghbal versus Daniel I. Werfel in his official capacity as Commissioner, Internal Revenue Service, and United States of America. Mr. Steele for the appellant, Ms. Lyon for the appellate.
Mr. Steele, good morning.
Good morning. May it please the court, Simon Steele for the Iowaska Church of Healing, which I'll refer to as the church. The district court made two separate errors in this case. First, it got the tax code question wrong because it misunderstood the interaction of the three statutes in this case: the tax code, the Controlled Substances Act, and RFRA. It misunderstood those statutes because it believed that there was what amounts to an exhaustion of administrative remedies requirement, that my client had to go to the DEA or go around the DEA.
Mr. Steele, I don't mean to interrupt. I don't know about my colleagues, but I'm very hard of hearing. Can you get closer to the microphone?
Sure.
Okay.
Is this better?
No,
That's
you can
great.
lift it up.
I think
No, you can't. Can't lift it up? Okay.
I think it's as high as it goes. But please do interrupt me if I'm hard to hear again. On the tax code question, the district court misinterpreted the interaction of the three statutes here: RFRA, the Controlled Substances Act, and the tax code. It misinterpreted them as effectively requiring exhaustion of administrative remedies, as requiring my client to get permission to exercise its religion from the DEA, or possibly in a lawsuit against the DEA before it could lawfully exercise its religion. In doing so, it also misinterpreted the key precedent on which the IRS relied from day one, the Bob Jones case. Separately, on the RFRA count, the district court got standing wrong. We articulated multiple theories of standing below, but one of them suffices. It's a straightforward economic injury. The thing we're complaining about in this case has always been half a piece of paper. The top half of page 355 in the joint appendix is the key part of the IRS final decision letter. There's never been any question that that's what we're complaining about. What that half a page does is it says we are denied a 501c3 exemption. The remedy we sought was to get a 501c3 exemption. The case law is clear. Frankly, economic common sense is clear. That a party denied a 501c3 exemption has suffered an injury which should be sufficient for the minimum constitutional standing that's required under RFRA. I'd like to focus my remarks on the tax code claim primarily. There are three key points that are undisputed or should be beyond reasonable dispute in the record. First, the church's purposes are religious and charitable. It serves multiple purposes, both the exercise of religion through its Iowaska sacrament and various other medical, healing, and charitable purposes. In addition, the church is expressly committed in its articles of incorporation to complying with the law and 501c3 requirements. Second, the one controversial purpose here, the Iowaska tea sacrament, is a sincere exercise of religion protected by RFRA. The IRS has never disputed that in this case. That may not be true of others who've claimed RFRA protection for using various controlled substances. It is true in this case. Third, the church has consistently acted as a law-abiding entity. It modeled itself on the Ochentro Church. Indeed, the IRS said in one of its determinations that the church is strikingly similar to the Ochentro Church. It modeled itself on the Ochentro Church because the Ochentro Church won its RFRA case in the Supreme Court, and because in 1994, without any exhaustion of administrative remedies and any contact with the DEA prior to that, the IRS had approved.
You say that the Ochentro Church won their case in the Supreme Court. The Supreme Court affirmed the entry of a preliminary injunction, but that wasn't a decision on the merits. And the Supreme Court was careful to say that in these RFRA cases, they depend particularly on the application to the person involved. So I don't see how you can kind of transmute, even if it was a victory for that church, onto any other entity. And that seems contrary to the Supreme Court's analysis.
Absolutely agreed, Your Honor. This isn't a case where we can just cite Ochentro and you can say, fine, we go home, we've won the case. However, the analysis in Ochentro is a very clear indication of how cases like this should be analyzed, consistent with the strict scrutiny that RFRA requires. This church has been found to be strikingly similar to the Ochentro Church. And While the Ochentro case was, and I'll concede this point to the government, decided before the DEA created its exemption process under the CSA. There are subsequent cases, including particularly the Oklahoma case in the Ninth Circuit, which were decided since that and are similar to our case on the facts. And the Oklahoma case in the Ninth Circuit expressly rejects the government's notion in this case that there has to be an exhaustion of administrative remedies before an Iowaska church can practice its religion.
Where does IRS say there has to be an exhaustion of administrative remedies as opposed to saying they don't have the authority to give an exemption to the CSA? That's the law of the land.
The IRS doesn't administer the CSA.
Does what?
Does not administer the CSA.
That's exactly right.
Sure.
But
Yes.
but if the activity we're talking about here is inconsistent with, it violates public policy, and there's no question that so far that is public policy. And the IRS has no authority to give an exemption for that. That has to happen somewhere else. So exhaust or not, that's not what IRS is saying. They're saying that under their mandate, this violates public policy, and therefore they're not giving an exemption.
Your Honor, I think it amounts to the same thing.
It may amount to it, but it really is not what they have said. They are simply saying that under the authority that we have to exercise, we can't grant an exemption. It is the law of the land, whether you think it should or should not be the law of the land. The Supreme Court's decision doesn't say anything inconsistent with that. They're not saying that that CSA notion is wrong. So I don't know how you can challenge what the IRS has done. They've done what they are mandated to do. They've looked at public policy. This violates public policy, and so that's that. If something changes later, then they might be in a different position. And then one of the things that might change later is that the Drug Administration may change its ruling, or some court may do something, but they haven't done anything that's inconsistent with the law, and they're following the law.
2 points, Your Honor. First, we do not concede that the sacrament violates public policy. Public policy for purposes of IRS law is what Congress says public policy is. Congress has legislated 2 different overlapping public policies that are relevant to the Iowaska sacrament here. One is that the use of DMT is generally prohibited, although there can be exceptions to it. The other is that religious sacraments, which the Supreme Court clearly indicated in Ochentro include, or potentially include the sacrament here, are protected by RFRA, and the government can only take adverse action to them, such as treating them as illegal, if the government satisfies strict scrutiny. My second point, quickly, is the Bob Jones case. As you said, the IRS has to do its job and not the DEA's job. What is its job? Its job here was to apply the Bob Jones case. The IRS said, that's what I'm doing. I'm applying the Bob Jones case. The Bob Jones case says you can only deny 501c3 status if there is, quote unquote, no doubt that this is against public policy. RFRA plus Ochentro plus Oklahoma at a minimum create very substantial doubt that the sacrament here is against public policy. If there are no further questions, I'll reserve the remainder.
All right. We'll give you some time to reply.
Thank you.
Ms. Lyon.
Thank you, Your Honor, and may it please the court. My name is Kathleen Lyon, and I represent Commissioner Werfel and the United States. Tax exempt status under Section 501c3 of the Code is a privilege conferred by Congress on organizations that qualify for it by carrying their burden of showing that they are organized and operated exclusively for one or more exempt purposes. Congress has also, in the Controlled Substances Act, prohibited the distribution of dimethyltryptamine, the Schedule I drug that the taxpayer here uses to make the ayahuasca tea, distributed in its ceremonies. Unless ayahuasca can show that the prohibitions in the Controlled Substances Act do not apply to it, it cannot carry its burden of showing that it is entitled to tax-exempt purpose. And it can't make that showing here because it has not obtained an exemption from the CSA, either from the DEA or through judicial relief under RFRA. I'll try to focus my comments in reaction to what Mr. Steele has argued. Number one, he says that the IRS must determine whether the church is exempt from the Controlled Substances Act under RFRA using a strict scrutiny standard that applies in RFRA cases. This gets the burden of proof backwards. The burden is on the church to prove that it's entitled to tax-exempt status, and they agree that the IRS lacks authority to determine whether an exemption applies here under the Controlled Substances Act. With respect to Ocentro, they've made the argument that the IRS has to grant tax-exempt status even without the exemption in hand because there's a presumption of legality. I think it's fairly clear from Ocentro and from the earlier discussion that Ocentro didn't hold that the use of ayahuasca is presumptively legal. It is a particularized case-by-case determination, and the context matters. And so that would have to be determined. They have asked DEA to make that determination, and it is currently considering it. With respect to Bob Jones, they've argued that they're entitled to a benefit of the doubt, or that they can only that the IRS can only deny the tax exemption if there's no doubt that the distribution is illegal. And the fact is, there is no doubt on that. But on a broader level, the no doubt standard isn't quite under Bob Jones isn't quite the right fit here for them. I don't think. In Bob Jones, the question was whether the conduct there was against public policy in the first instance. We don't have that issue here. Congress has spoken very clearly. And the question is whether ayahuasca is exempt from the application of the Controlled Substances Act that bars its conduct. So, and the IRS shouldn't determine that because it doesn't have authority to determine that. And ayahuasca agrees with that. On the administrative exhaustion point, I'll just point out, as has been said by Judge Edwards, I believe, what is happening, ayahuasca's problem here is not an administrative exhaustion problem, it is an authority problem. And the IRS simply doesn't have the authority to make the determination that they want it to make. They're seeking the wrong remedy here against the wrong agency. If the court has no further questions.
Mr. Wilkins? Judge Edwards?
No.
All right, thank you.
Thank you.
Okay, why don't you take 2 minutes, Mr. Steele?
Thank you, Your Honor. I can be very brief. The IRS does not have the final authority to determine legality under the CSA. That's agreed. The IRS, however, has the authority and has the obligation to make the determination that it attempted to make applying the Bob Jones test. That determination is one of public policy and law. I heard my friend Ms. Lyon talking about the burden of proof. There's a lot of discussion of the burden of proof in the IRS's brief. I haven't heard the IRS identify a single disputed factual question in this case. The issue here isn't who has the burden of proof. The issue here is when there is a genuinely and substantially disputed question of what public policy, as determined by Congress in both the CSA and RFRA, requires, how is the IRS to resolve that question? And Bond Jones provides the answer to that. It says that only if there is no doubt that the purpose is against public policy should the IRS reject 501c3 application.
So you
on that
agree
basis.
if I think, as a judge, if I think there is no doubt that this violates CSA public policy, you lose.
Correct. I agree. Anything else?
Thank you.
Thank you.
Honorable Court now stands adjourned until Tuesday, March 12th at 9:30 a.m.